I'm a senior associate at AGHS, and normally I undertake most of the constitutional litigation cases. And as Dr. Sadaf previously pointed out, I've also served as the lead legal expert for the European Union. I've specifically worked on gender issues that arise out of international development projects and other gender issues and that need to be incorporated in grant contracts for future development projects in Pakistan. So we previously looked at a lot of operational practice and the way private bodies understand the legal framework and the international labor law framework that exists in Pakistan and how specific complaints that are addressed to them in those legal framework, how do those development bodies address those issues and what kind of standards are incorporated. In doing so, we've been able to undertake a very extensive study of the Constitution of Pakistan. And Article 25, 26, 27 are the specific equality provisions that now exist in the Constitution. And Article 25 is the overarching equality principle that exists in the Constitution, which provides that there will be no discrimination on the basis of gender. Now, gender is the only protected ground under Article 25, whereas under Article 26 and under Article 27, there are 4 other protected grounds: caste, race, religion, residence, and place of birth. But under Article 25, gender is the only protected ground. So the effect that this has is that the when we have an issue in which there is 2 protected grounds, for example, when there's a minority woman that is being persecuted, she's not just being persecuted because of her gender, but she's also being persecuted, facing additional problems because of her religious minority status. Now, only one of those protected grounds is currently recognized by the Constitution. When it comes to an analysis in our courts of whether there is to be any legal recognition and hence whether a law or a practice or a custom is illegal because of the persecution that the victim is facing because of her religious status, there the courts are only going to look at whether it was reasonable or not. We have a principle which we've appropriated from other comparative jurisdictions, which we call the reasonable classification rule. It's a two-pronged test in which the courts are going to look at how the executive or the legislature has actually brought about reaching this classification. Why have they discriminated on a particular person? And they are going to see whether there was any intelligible differentia, whether there was any reasonable classification, and if it is reasonable, it is completely up to the courts. Even in America, we've seen this principle fail when it comes to specific gender issues such as pregnancy discrimination, which is which used to be a very intense issue in America because women who were now being additionally being incorporated into the workforce, their pregnancy status was not being recognized by the legislature. And when they tried to approach the courts on the basis of the non-discrimination principle, that other disabilities, other incapacities are remunerated in the form of benefits. For example, if a male has testicular cancer, he is entitled to benefits from his employer, but if a woman is unable to work for 9 months or for 3 months, that particular disability is not recognized. So this was impugned under the non-discrimination principle, and under the reasonable classification rule, courts decided that there was no discrimination, which is why they added additional protected grounds, and the legislature had to specifically say that now we are going to hold any discrimination on the basis of gender, race, religion, caste, sex, and all those protected grounds are specifically enumerated in Title 7 of the Civil Rights Act 1964 in America, for example. So, under the present Pakistani constitutional legal framework, there is only one protected standard, which is sex, which is why other protected standards are not recognized. And women who are from other protected religious or ethnic minorities who face double persecution on the basis of not just their gender but also on the basis of their minority status, they do not receive the intersectional benefit or protection that the Constitution ought to provide. So the CDOC committee, while evaluating Pakistan's fifth report, periodic report on the implementation of the CEDAW Convention, specifically cited that Pakistan needs to amend Article 25. It needs to add other protected grounds so that intersectional discrimination can be prevented. And Pakistan has accepted that reform recommendation. I have a quotation from Pakistan's response to the issues that were framed by the CEDAW committee. And the government of Pakistan held that it is in the process of amending Article 25 of the Constitution. The proposed amendment expands the definition of equality and discrimination. It proposes that the state shall not discriminate directly or indirectly against anyone on the grounds of race, gender, sex, pregnancy, marital status, ethnic or social origin, color, age, disability, religion, or language. Now, this was back in 2018. We have not yet seen any progress towards this amendment. We've never seen a proposed recommendation or a discussion in Parliament about this against this recommendation, even though we've told the CEDAW committee that we are in process of making this recommendation. So this should be one of the priorities right now to amend Article 25. Secondly, there's one more recommendation that I'd like to discuss. Pakistan, as a legal practitioner and especially as someone who regularly appears before the High Court in its constitutional jurisdiction, we see an uncertainty, especially in our courts, regarding implementation of international commitments of Pakistan. So, especially in child abduction matters, when there's a child that has been illegally removed from another country and we try to use the Hague Convention and we try to convince our judges that this convention is binding on Pakistan, and if there is a matter that is before our courts, then the convention should be used and the child should be returned. Our courts are very ambiguous regarding the applicable nature of those conventions. The Federal Shariat Court, ironically, in 2018, in investigation over a case of gender discrimination, evaluated the CEDAW Convention. And the Federal Shariat Court came out with a very novel interpretation of our Article 227, which is the Islamic provision, Islamic injunction provision in the Constitution. The Federal Shariat Court held that Islam specifically requires that people should abide by their commitments and promises must be kept. So if there is a convention that the state of Pakistan has specifically ratified and acceded to, then it is automatically binding on our courts. And the CEDAW Convention, by that effect, is automatically binding on our courts, and there is no need for specific acts of parliament which further incorporate our international commitments. I believe that the uncertainty is still there. We've tried to present the Federal Shariat Court judgment in a lot of our cases, but our judges still remain very ambiguous and they are very reluctant to rely on international conventions in the absence of any other law. So this is one recommendation which I think would cure this uncertainty if there is a specific amendment in the Constitution or a specific provision is added which requires implementation of international commitments directly in our courts, even if it is limited to our human rights commitments. That would suffice for the purposes of curing most discrimination aspects that are presently raging in our society and which Pakistan has promised to most international partners that we are working or those are binding on us and we will cure them. So finally, there's one last recommendation that again stems from the Islamic nature of the Pakistan Constitution. It is there are several judgments of the Federal Shariat Court which recognize a distinction between the male and female gender. I know this is a very controversial subject, and a lot of the previous esteemed speakers specifically touched upon this topic, that there is no need to recognize that distinction. But I believe that there is some benefit that we can get from this distinction as well. That specific benefit is with respect to certain dignity benefits that Islam recognizes with respect to, let's say, the female gender. So the article, we are one of the only constitutions, not the only constitutions, we are one of the few constitutions that has a dignity provision in our constitution. I believe South Africa, Canada, not even India has a dignity right in the constitution. So I think a specific amendment that recognizes the dignity of women would be very beneficial and would help the cause of curing gender discrimination a lot. Thank you. The lights are off, so I think this is this is
I think this is a wrap, although
This is a wrap.
Dr. Shah had some